Important topic, the digest of Supreme Court judgment on parallel proceedings, same subject matter, so-called notice versus summon issued. So we are going to discuss many important pointers and guidelines as issued by Honorable Supreme Court on the stated subject matter. Okay. So without any further delay, let me start with why this Supreme Court judgment is so important. It is in the context of that we have seen that at same time we are getting investigation initiated, let's say by DGGI, and then let's say it is being started by state anti-evasion GST authority also at same time. So we as a taxpayer are struggling with. And we say when DGGI has already initiated, why states should come in? Is it not in violation of cross empowerment? Second situation could be that investigation started by GST authority and they have issued, let's say, so-called notice. And then again, central DGGI or anti-evasion authority coming in and they are investigating you for the same period. So is it not the same subject matter? So we are, as a taxpayer, we are saying that you have already issued, state GST authority has already issued so-called notice. Why then central anti-evasion or DGGI authority coming in and investigating for the same period for same subject matter? So what is the same subject matter is a point of contention. And what is the meaning of parallel proceedings? Third situation, that being as a taxpayer, I'm under state jurisdiction, state GST jurisdiction. Whether central anti-evasion or DGGI can initiate any action, enforcement action against me or vice versa. Whether doable, what is the meaning of intelligence-based enforcement action initiated who is not your jurisdictional proper officer? Other situation could be, I'm just drawing an example for you, that in one of the writ petition before Honorable Delhi High Court pertaining to one of the petitioner, we have filed a writ petition where state has already issued the so-called notice on fake ITC pertaining to one supplier, and for 4 financial years they have passed the impugned order also. So let's say 17, 18, 18, 19, 19, 20, 20, 21. Order is also being passed, impugned. We have gone for appeal remedy. But in 22, 23, Central Anti-Evasion Authority coming in and they are deciding the subject matter on same subject matter, same supplier, and passing the impugned order and covering 6 years, out of which 4 years already been crystallized by the state GST authority. Irony here is GST authority has crystallized the demand under section 73 and center is deciding under section 74, fraud case. So there are many if and buts which is moving around. So this Supreme Court judgment which we are going to discuss today is the important one. And I will request each one of you to pay your deep attention. I'm going to run the judgment I have picked up the relevant para, which I have colored also, to draw your attention. So we will discuss everything one after another, and we will try to finalize what is the difference between summon inquiry versus proceedings when so-called notice is being issued. So these are the factors: parallel proceedings, cross empowerment, intelligence-based enforcement action. We are going to discuss many pointers today because this is a burning topic today. In the case of Armor Security India Limited, let me say the judgment first, and then we will start our discussion of the day. Just allow me. Hope you can see the judgment which I'm going to discuss with each one of you today, and the relevant one. This judgment coming from Supreme Court, Armor Security India Limited. And then we will first look at the fact why this SLP has gone before Honorable Supreme Court. This SLP has gone to Honorable Supreme Court because of the judgment and order passed by Delhi High Court, by which Honorable Delhi High Court has dismissed the writ petition filed by the petitioner and declined to interfere the summon issued to the petitioner dated 16th of January 25 and 23rd January 25 under Section 70 of CGST Act by the Central Delhi East Commissionerate, respondent number 1. So, Honorable Delhi High Court has declined to interfere because petitioner wanted that summon issued by Central Delhi East GST Authority is on same subject matter, so that need to be dismissed. But Honorable Delhi High Court has said we cannot interfere when summon is only being issued. So when writ petition got dismissed, SLP was filed before Honorable Supreme Court. So what is the factual matrix? Petitioner is a public limited company and engaged in providing security services. Now these dates are important, must bear in your mind. On 18th of November 2024, petitioner has received the so-called notice under Section 73 non-fraud case from respondent number 2, which is Delhi GST Authority. So Delhi GST Authority, Delhi SGST Authority has issued a so-called notice under Section 73 for a period financial year 2021 for alleging amount of 1.24 crore. This allegation made in the so-called notice was on 2 counts: that net tax underdeclared due to non-reconciliation of turnover in other return and eBay bill information, and second was excess claim of ITC. On that account, demand was alleged 1.24 crore. So so-called notice issued by Delhi SGST Authority, again dated is 18th of November 2024 for the financial year 2021. Now on 16th of January 25, a search was conducted by Delhi Anti-Evasion Central GST Authority, Delhi East, which is respondent number 1. And Panchnama was drawn, summon was issued under section 70 to 4 director of the petitioner company, requiring them to produce document. So I'm not getting into whether Panchanama later on got signed, copy handed over, inspection or search when conducted with the department giving the copies of the same or not, because these are not discussed in this judgment. But we have seen whenever department comes in number of cases, you may endorse in your comment box. When they come for inspection or search, they only show a copy and said read and sign. They don't give us the copy. Why they will not give the copy to us, which is required. But this is not the subject matter in this judgment, but importantly, when I'm discussing, sometimes Panchnama made and but not signed on the day of search and not given the copy. These are the instances we are finding, and it is not going towards ease of business. So I'm just picking some of the pointers where we need to look at and provide ease of business. But nevertheless, here summon was issued, Panchanama was given. Summon was given to 4 directors on 16th of January 2025. Next date is 23rd January 2025. Petitioner received another summon by same Delhi Central GST Authority that you come and provide the documentation and details. Petitioner on 24th of January 2025 submitted a letter. Why is submitting letter important? Addressing to the authority, respondent number 1, saying that on similar grounds, including ITC claimed from cancelled supplier, we got the so-called notice from Delhi SGST authority. So he's writing to the Central GST authority anti-evasion, saying that these summons when you're issuing to me is of no use, because I have been issued a so-called notice on same cancelled suppliers, and that is being issued by Delhi SGST authority. And that is the reason he was aggrieved by these summon dated 16 January and 23rd January 2025. And saying that when the respondent number 2 has already initiated the investigation and issued the so-called notice on same issue, respondent number 1, Delhi Central Anti-Evasion Authority, does not have jurisdiction in view of Section 6, subsection 2, Clause B of CGST Act. We all know what is the Section 6, subsection 2, Clause B. It's simply saying if state has initiated the proceedings on any subject matter, then if state has initiated, then central should not take up the matter on same subject matter. So just to provide relief that there should not be parallel proceedings, that is what the safeguard provided under section 6 subsection 2 clause B. That is the reason writ petition was filed before Delhi High Court, that I got the so-called notice. Now they are issuing summon, central is issuing summon. So this is in violation, beyond jurisdiction. When we look at the provision under section 6 subsection 2 clause B, so this was the factual position. Honorable Delhi High Court has said that expression any proceedings in section 6 subsection 2 clause B cannot be construed to include search or investigation. So they are delinking. When we are reading proceedings under section 6 subsection 2 clause B, It is not same as search or investigation. So summon is something different. The High Court took the view summon or investigation pursuant to a search constitute only a precursor to the formal proceedings. It distinguished such summon from assessment, noting that summon is primarily intended to elicit information. So look at the way Honorable Delhi High Court has said that summon, which is for the search or investigation, is something different. When you look at the proceeding, the term used proceedings under section 6 subsection 2 clause B. In this context, this judgment has come. So we have to really understand the judgment in detailed terms. So High Court noted that intent of statute is to prevent parallel proceedings. Relating to parallel proceedings, intent of statute is to prevent parallel proceedings. Relating to assessment, an assessment can happen only when so-called notice is being issued, particularly those initiated under section 73 non-fraud, section 74 fraud case of CGST Act, or any other analogous provision, maybe section 76. At the stage of issuing summon, the authority are merely engaged. Please read, these paras are important. This judgment is of 70 pages. We are going to discuss within 60 minutes. So I have just picked up the important paras for the immediate digest and understanding the subject matter. At the stage of issuing summon, authorities are merely engaged in gathering the information from the SAC based on the material collected. Thus far, as it is not yet possible to determine the specific course of action the authority intends to pursue. So they are delinking the search and investigation is only precursor to any proceedings as referred under section 6 subsection 2 clause B of CGST Act. So this is interesting and important. If you are getting summon from central and state, but no so-called notice is being issued, whether parallel proceedings permissible? Can you say it is violating section 6 subsection 2 clause B? Sometimes we have seen anti-evasion authority from the commissionerate and DGGI from central, but pan-India. Let's say they are picking up supplier pan-India. And commissionerate anti-evasion is only focusing jurisdictional supplier. So a lot of factors need to understand. And this is what this judgment is giving important way forward guidelines to taxpayer and to the tax department both. Having said that, what was the submission of the petitioner? What some petitioner has said? Petitioner has said that section 6 subsection 2 clause B expressly prohibit parallel proceedings on the same subject matter by both central and state GST authority, which was the first point. And they're saying that availability of ITC in respect of cancelled dealer, supplier is barred because that was the so-called notice issued to me. Now, central is issuing summon on same subject matter. This is what the point of contention from the petitioner side. Second point which was put forth by the petitioner is, petitioner does not dispute jurisdiction or authority of central GST authority. So they are not disputing jurisdiction in respect of subject matter not covered by the so-called notices issued by the state authority. He further contended High Court has made error in interpreting Because High Court has said that Section 6, subsection 2, clause B, proceedings are different when you look at summon issued for the search or investigation. So these are two different things. So petitioner is saying, no, Honorable Delhi High Court was not correct. So this is what the petitioner argument. Even petitioner has drawn the attention of the Delhi High Court, saying that Section 146 of CGST Act, important, you must keep to your mind, which may be important for your defense in other subject matter. Submit that common GST portal reflects complete record and status of all proceedings initiated by either state or central GST authority. What petitioner wanted to draw: when state has initiated the action, issued the so-called notice for cancel dealer, this was visible to the central GST authority. Then whether central GST authority would be permitted to initiate action on same subject matter. So they are saying if this is being so identical, then respondent number 1 should not have issued the summon to the petitioner. This was the point drawn here. Now they are referring, if we have to look at GST, though it's a dual levy by central and state, but it needs harmony as a foundational principle of cooperative federalism. They need to have harmony between themselves. If that is visible to them on a portal, that state has initiated so-called notice, then central should not initiate on same subject matter by issuance of summon. This was the point put forth by the petitioner. And he has also drawn one circular interesting, dated 5th of October 2018, which is again emphasizing that harmonious exercise of power by state and UT. That is what it is being referred. So having said that, this was the petitioner defense. He has pleaded that impugn order passed by the High Court because the Honorable Delhi High Court declined to interfere with the summon issued by Central GST Authority. So he has pleaded that that order must be set aside, and the summon issued on dated 16 January and 23rd January 25 be declared as having been issued without jurisdiction. So this is all factual position and petitioner submission before Honorable Supreme Court. Now, what is the analysis? Analysis is being done with respect to divergent judgment coming on the stated subject matter. So while analyzing, the question framed by Honorable Supreme Court is whether action of respondent number 1, Central GST Authority, as complained of, amount to an initiation of proceedings because they have issued only summon in respect of same subject matter for the purposes of Section 6, subsection 2, clause B, because so-called notice was already issued by the state Delhi SGST authority. So this was the question. So the first question again crystallized, which is decided by Honorable Supreme Court, whether issuance of summon, please, it is important, whether issuance of summon can be regarded as initiation of proceedings within the meaning of Section 6, subsection 2, clause B. So this was the first question framed. And then it was acknowledged by Honorable Supreme Court that there is a contrary views by different High Court on the said issue. So we know that contrary view, but now Supreme Court has decided. So that is going to be silver lining. So we have to really see this judgment for getting more clarity. So what is being done? This judgment which I'm referring to, the decision interpreting the term of proceedings in contrast to inquiry or investigation. Honorable Supreme Court has heavily relied, I will say this, of Allahabad High Court judgment in the case of GK Trading. So if you find what is the crux of Allahabad High Court judgment in GK Trading, it's relied upon by Honorable Supreme Court for giving this judgment. So they are discussing what is the meaning of proceedings. When we talk about section 6 subsection 2 clause B versus when someone is being issued for inquiry or investigation. So they are doing interplay between section 6 and 70 of CGST Act. High Court held that, and very interestingly, wherever I have colored and underlined, I thought these are the paras important for you to digest. Of course, this judgment would be available in description box, which you can download later and then read the judgment for your academic purpose, but interesting one. Allahabad High Court held term inquiry as used in section 70 for issuance of summons is not synonymous, not similar with proceedings under section 6 subsection 2 clause B. That was the judgment of Allahabad High Court. Court clarified proceedings under section 6 subsection 2 clause B include action relating to assessment, demand, and penalty, such as those initiated under section 73 or 74 respectively. So Allahabad High Court said and held that when we are looking proceeding, the term initiation of proceedings under section 6 subsection 2 clause B, we are referring that proceedings under section 6 subsection 2 clause B would be action relating to assessment, which is more particularly with respect to 73 or 74. Court interpreted the phrase same subject matter in section 6 subsection 2 clause B refers to the same cause of action concerning the same dispute being adjudicated before the proper officer. In court's view, reference to the subject matter implies an adjudicatory proceedings founded on an identical cause of action. So they are differentiating that issuance of so-called notice and adjudication proceedings referred its proceedings, which is more relevant for section 6 subsection 2 clause B as against the inquiry which is being initiated by issuance of summons under section 70 of CGST Act. Having said that, Honorable High Court of Madras has also dealt with a challenge to summon issued by the respondent on the ground that appellant's company fell within the state jurisdiction and the respondent is an authority with the central jurisdiction. So here dispute was, how come summon is issued by central when we are falling under state jurisdiction? So this judgment again emphasizing the meaning, the scope of the term proceedings when we are referring to section 6 subsection 2 clause B versus section 70 of CGST Act. So they are clearly saying the word proceedings and inquiry cannot interchangeably be used to say there is a bar to invoke power under section 70 of CGST Act. So proceedings as referred in 6.2b is something different when we look at inquiry under section 70 by issuance of summons. So these are the judgments. So I'm not going to read all the judgment one by one, but all the divergent judgment are being picked up and discussed in this Supreme Court judgment, which I have highlighted for what matter these writ petition gone before different high court. So I'm just going down further. So having said that, when we are going further, one of the judgment which is being passed by Kerala High Court has clearly said and held initiation of an inquiry or issuance of summons under section 70 cannot be equated with the initiation of proceedings for the purpose of section 6 subsection 2 clause B. Term initiation of proceedings is in reference to issuance of so-called notice, either under section 73 or 74. And they have further observed the said circular which we have discussed dated 5th of October 2018. So I'm not reading all the judgment, but I've highlighted where you should pay attention. You can download this judgment and read later. So having said, now what are the important pointers? Even Punjab and Haryana High Court, they have held any action taken by any department amount to judicial proceedings, but department are within their right to initiate proceedings and take them to their logical conclusion. So a lot of things, divergent perspective, which is being taken into consideration. Then second important question, which is being considered by Honorable Supreme Court for analysis, the framework of single interface and cross-empowerment of powers under Section 6 of CGST Act. In a layman language, that there are dual levy, central and state. Whether I am as a taxpayer is under control of both the authority, or there would be single interface. And it was clarified with a lot of, initials when GST got introduced. They have said, no, taxpayer going to be divided. And a clarity was provided how to be divided, which taxpayer would be going under state and which taxpayer would be going under central. So let's say if I'm going under state jurisdictional authority, then state will decide even for central CGST, SGST and IGST. There should not be two authority that the CGST and IGST would be decided by central and SGST would be decided by respective state. No, there would be single interface. That is the reason that provision section 6 is important. And what is cross empowerment? I'm under state jurisdiction where the center is having power to initiate any proceedings against me. That is called cross empowerment, doable. And we have seen that intelligence based enforcement proceedings can be initiated even by central, though I am falling under state jurisdictional authority or vice versa. So this was the pointer they have discussed at length and decided, yes, doable. So again, framing GST consciously decided taxpayers should not be subjected to jurisdiction of both central and state. That is the region they have made single interface, which I have discussed, and he will decide everything, CGST, SGST and IGST. And what is the meaning of cross empowerment? Of course, dual empowerment was intended to maintain robust enforcement capabilities. So you may be under state jurisdiction, but center can initiate action against you to maintain robust enforcement capabilities and prevent any tax evasion, while preserving the administrative clarity of the single interface system. So that is how they are discussing that section 6, what is the relevance under subsection 1, and it is must, you can read for a time being for getting more clarity, that section 6 was incorporated into the statute. Subsection 1 authorizes the officer appointed under SGST or UT to be proper officer for the purposes of CGST Act. Means even SGST proper officer can decide and determine even for CGST. That is what the meaning which is coming out. So section 6 of CGST Act and the identical pari materia provision are existing in respective state and UT statutes. So having said everything, when they talk about cross empowerment, they are saying yes, central and state shall have power to take intelligence-based information enforcement action in respect of entire value chain, is reflected in the circular dated 5th of October 2018 as reproduced above, and they are discussing at length here. So this is all. So term cross empowerment I have explained, but again it is being clarified in para 47. For this purpose, for the cross empowerment, both central and state have been armed with power to initiate intelligence-based enforcement action. So this is what enforcement. So I'm not reading in all the paras, but colored means it is important for you to read later. We are discussing the crux. Third question, which was considered by Honorable Supreme Court, scope and ambit of initiated any proceedings under section 6 subsection 2 clause B, when we will say that there is initiation of any proceedings under section 6 subsection 2 clause B, summon issued inquiring about details and document during inspection and search, can we say it is initiation of any proceedings? Or when so-called notice is being issued for assessment, for non-payment of tax, short payment of tax, wrongly availed ITC, or utilized ITC, or erroneous refund. What is the meaning of initiation of any proceedings? Under section 6, subsection 2, clause B, they are clearly saying that proceedings, any proceeding which is referred under section 6, subsection 2, clause B, and as discussed by Honorable Allahabad High Court in the case of GK Trading, it is only by issuance of so-called notice under section 73 or 74. Whereas summon is being issued only for inquiry which is distinct, different. When we look at proceedings under section 6, subsection 2, clause B, this is what the crux they are discussing. So they are saying section 70 empowers proper officer to summon any person whose presence is considered necessary for giving evidence, producing document, any other relevant material in an inquiry. Issuance of summon is one of the instruments employed by department to obtain information, documents, or statement in case involving suspected tax evasion, which is distinct and different when we look at section 6, subsection 2, clause B. And that is what they are saying. At the stage of issuing summon, department is yet to determine whether proceedings should be initiated against the assessee. Such evidence gathering and inquiry do not constitute within the meaning of section 6, subsection 2, clause B. The mere issuance of summon cannot be equated with the proceedings barred under the Act. What is barred under the Act? Parallel proceedings barred under the Act is only when a so-called notice is being issued. That is called initiation of proceedings when we are discussing section 6, subsection 2, clause B, where summons are different. It is only precursor. So in that case, summons is being issued, there may be, department may drop the proceedings, may not initiate, or may go ahead further. So subject matter, same subject matter, parallel proceedings, it is all only when it is initiation of so-called notice for the assessment and determination of tax liability. So as I said, that the Honorable Supreme Court has relied on Allahabad High Court judgment, GK Trading, and they say we affirm and appreciate view taken by the High Court of Allahabad in GK Trading and High Court of Kerala, KT Sai Dalbi. The High Court Allahabad rightly held issuance of summons cannot be conflated with the statutory step taken up, conclusion of an inquiry. Similarly, High Court of Kerala was correct in holding that initiation of inquiry or issuance of summons does not amount to initiation of any proceedings. The phrase initiation of any proceedings refers specifically to the issuance of notice, so-called notice, under the relevant provision of GST Act. So that is how they are now saying this petitioner was served so-called notice on 18/11/2024 by Delhi SGST authority under section 73. Thereby it is called initiating proceedings. So they are saying that so-called notice which was issued by Delhi SGST can be termed as initiating proceedings. Petitioner has only impugned. Petitioner has filed writ petition before Delhi High Court, which Honorable Delhi High Court has declined to interfere. So petitioner has only impugned the summons dated 16 January 25 and 23rd January 25, respectively issued by Delhi Central Anti-Evasion Authority for production of document. At the summons stage, it cannot be predicated with certainty. The subject matter of proceedings will be identical. So what they are saying, how you can conclude the subject matter covered in a so-called notice and for want of document and details going to be same? This is what the conclusion coming out. At the summons stage, it cannot be predicated with the certainty the subject matter of proceedings will be identical. The mere presence of an overlapping aspect, under investigation does not ipso facto render the subject matter as same. So maybe tomorrow, department, even though you got so-called notice, let's say in one of the case which I referred today, by Delhi SGST authority, subsequently center is issuing summons for want of details and document, you are not permitted as a taxpayer that there is overlapping aspect under investigation unless it is being crystallized by issuance of so-called notice by central GST authority. So let's say for clarity's sake, I got the so-called notice by Delhi GST for 4 initial financial year for which I filed the writ petition. There was allegation of fake credit against one cancelled supplier. So-called notice was adjudicated against me. I've gone for appeal also. Later on, center is also determining for 6 years on same subject matter because same supplier and fake ITC. Can I say it is overlapping? Now I can say it is overlapping because both the authority has issued so-called notice and impugned order. I can always go and file a writ petition, and that is not being permitted when we look at section 6 subsection 2 clause B. But if Delhi has decided for 4 financial year, pass the order, center has issued only summon and they have not gone ahead, can you say it is overlapping? As per this judgment, Honorable Supreme Court, the legal jurisprudence coming out, you must go and submit the details and document unless and until Central GST decide by culmination into issuance of so-called notice. If the subject matter is identical, then you can say same subject matter. Otherwise, it is not same subject matter, and you are under obligation to provide details and document whenever summon is being issued to you, which is distinct when we look at section 6, subsection 2, clause B. This is what the crux coming out. So having said, High Court correctly held the term proceedings does not encompass summon issued pursuant to a search or investigation. As at the stage of issuance of summon, department is merely engaged in gathering information. We are in agreement with the finding of the case of search is clearly distinct and separate from proceedings initiated only after issuance of so-called notice. So just look at the way this judgment coming and just make the comparison in terms of our ease of business. See, in my considered view and my humble submission, we all are looking for ease of business. We know dual levy was national compulsion, cooperative federalism. There should be harmony, right? When so-called notice, I'm just making a point, you say in a comment box, whether right or wrong. And section 146, which is referred in this judgment, is also emphasizing. When state has issued so-called notice, passed the order, stating the name of cancelled supplier, if center is again picking up the same subject matter, first they are issuing summon, maybe for want of details and document, but they are only highlighting that cancelled supplier for which you got impugned order passed by Delhi GST authority. Whether these kind of things are permitted, whether this is going to provide ease of business, even central could have seen on GSTN portal what is being decided by Delhi SGST authority. They should not have initiated any kind of summon or subsequent issuance of so-called notice and then going ahead and passing the impugned order. How we will get ease of business? I'm tossing up. This is a subject matter we need to consider. And it is visible to them. They can also see GSTN portal as a taxpayer is being asked to look at portal regularly. Nevertheless, this is the point I wanted to draw here. Having said, you know that so-called notice is being issued for different subject matter when non-payment of tax, short payment of tax, credit wrongly availed, credit wrongly utilized, erroneous refund. Either it can be done through initiation of so-called notice, or if you pay before issuance of so-called notice, 73 subsection 5, 74 subsection 5, then no so-called notice need to be issued. So we have discussed at length. They are also reading the circular number 5, circular dated 5th of October 2018. So not going in detail part of it. Another question, whether subject matter within the meaning of section 6 2b includes all matter dealt within the summon under the act. Now, I'm sure you must be in a position to write in a comment box. Can you say subject matter within the meaning of section 6 2b includes all matter dealt with in the summon under the act? Obviously, no. That is what it is coming out. So I'm not going into detailed part. So to interpret the term subject matter as employed in 6.2b, it is evidently clear that the purport of the said section that subject matter need to be understood in a perspective of initiation of proceedings by issuance of so-called notice. All right. So having said, so in other words, 6.2b subject matter is intrinsically tied to the determination of the specific violation under the scrutiny or liability alleged to be unpaid. So statutory bar is triggered only when two proceedings against the same taxpayer. So when central and state both are issuing so-called notice deciding on same subject matter, then it is called a same subject matter and initiation of proceedings. Someone is not. So where proceedings concern distinct infraction, please read this line. This is very interesting. Where proceedings concern distinct infraction. Infraction means different. Each department is entitled to proceed within its respective statutory remit without infringing the provision. Now, with this kind of conclusion, what I'm getting, even for the same financial year, you may have more than one so-called notice. You may have more than one impugned order, because it can be stated that each of the so-called notice on a separate subject matter. So little distinct infraction can create separate identity, separate subject matter. Then you can't say overlapping and parallel proceedings. So this is what crux which is coming out from para 87. So having said, section 6.2b at large, we lay down twofold test. Now this is what Honorable Supreme Court is saying. We lay down twofold test that coming out from above discussion. Whether a subject matter is same, first, subject matter will be considered the same if an authority has already proceeded on an identical liability of tax or alleged offense by the SSC on same facts. So by issuance of so-called notice. And secondly, if demand or relief sought is identical. So in the present case, learned counsel for petitioner contended subject matter of proceedings pertain to the availability of ITC in respect of cancelled dealer. However, this contention fails for two reasons. First, someone on his own cannot reveal the subject matter. Secondly, subject matter can be ascertained only from the so-called notice. The apprehension of petitioner cannot be accepted merely because fact of ongoing inquiry overlap with the subject matter of so-called notice already issued. So I hope upon crystallization of the subject matter through so-called notice, pursuant to an intelligence, no other tax authority may assume jurisdiction over it. So intelligence based as per circular that need to be crystallized by the person who is initiating. Provided it is ascertainable that consequences of any further departmental action would be subsumed within the same subject matter. What is the meaning? What is the purpose of an order under section 6.2b? Simple, to avoid parallel proceedings. There should not be overlapping power, but only when it is by issuance of so-called notice, which is meant for assessment purpose. So having said, now we must come to the last and important part of Honorable Supreme Court. And this you must read line by line, because this is now going to be silver lining and in all the judgment pending before High Court or way forward writ petition, this Honorable Supreme Court judgment going to be decided, to be relied upon, to be taken into consideration. So you must take a note line by line. What is being concluded? We summarize our final conclusion as under, and I'm reading each of the important pointer. Roman 1, 6(2)(b) of CGST Act, an equivalent state enactments bar initiation of any proceedings on same subject matter. Quite obvious. And it is only when so-called notice is being issued on stated same subject matter. That's good. So you have to prove if SGST has also issued so-called notice, Central has also issued so-called notice, again same cancel supplier, alleging fake ITC, then you can say same subject matter, which is being barred. So they can't do so. Any action arising from the audit of accounts or detailed scrutiny of returns. So audit of accounts, section 65. Detailed scrutiny of returns, section 61, must be initiated by tax administration to which taxpayer is assigned. This is important. So scrutiny of return, which is done by your jurisdictional officer, proper officer, he must initiate the action against you, not by any other authority. Or if audit, any action arising from audit, then proceedings must be started by your jurisdictional tax administrating single interface. That importance will come here. Intelligence based. Now, single interface gone for the audit and scrutiny of return. Now coming intelligence based enforcement action can be initiated by anyone of the central or state. So anyone can do, vice versa, despite taxpayer having been assigned to other administration. Simple, if you are assigned to a state, even center can initiate action against you when it is intelligence-based enforcement action. Parallel proceedings should not be initiated by other tax administration when one of the tax administration has already initiated intelligence-based enforcement action. So quite obvious. It can't be so overlapping. All action that are initiated as a measure for probing an inquiry or gathering of evidence or information do not constitute proceedings within the meaning of section 6(2)(b). So this is creating eye-opener for me as well and for you as well. At same point of time, Central GST Authority initiated issuance of summon. Here, state has also issued the summon to you. When it is not proceedings, when we are referring to summon under section 70, can we go and argue it is proceedings overlapping, it is being barred under section 6(2)(b? Looks like to me now both can, but this is not giving good picture. Hope you all are getting my point. Expression initiation of any proceedings occurring in 6(2)(b) refers to formal commencement of adjudicatory proceedings by issuance of so-called notice and does not encompass the issuance of summon or conduct of any search or seizure. So summoned by different authority, they are open-ended, they can go ahead. We can't take any relief when we talk about section 6(2)(b). Expression subject matter refers to any tax liability, deficiency, obligation arising from any particular contravention which department seeks to assess or recover. Where any two proceedings initiated by the department seek to assess or recover an identical or partial overlap in the tax liability, deficiency or obligation arising from any particular contravention, the bar of section 6(2)(b) would immediately attract it. Fortunate part, writ petition which we filed before Delhi High Court, 4-year decided by Delhi CGST, whereas Central is deciding for 6 years, including those 4 years on same subject matter. At least we will get the relief when we look at this particular conclusion and held position by Honorable Supreme Court. Where proceedings concern distinct infraction, please, this is again factual. To what extent this distinct infraction is a subject matter and need to be decided separately. So they are saying when the proceedings concern distinct infraction, just in the name of distinct infraction, same would not constitute the same subject matter. Even if tax liability, deficiency, obligation is same or similar, so even a small distinct infraction might create distinct nature of the subject matter, and the bar under section 6(2)(b) would not be attracted. Twofold test for determining whether subject matter is same entails, first, determining if authority has already proceeded on an identical liability of tax or alleged offense by assessee on the same facts, and secondly, if demand or relief sought is identical. Now here, Honorable Supreme Court is saying we issue the following guidelines to be followed. We are into 9th years of GST. We all are talking about ease of business. Recently, Honorable Prime Minister on Independence Day, 15th August, had announced a major Jain 2 GST reform, where he talked about structural reform. He talked about ease of business, ease of living. Indeed, I'm saying that GST require a lot of improvisation in compliances. Portal, which was not ready when GST got introduced. It is only being developed over a period of time. So there is a law and there's a portal. Some of the provision which is made applicable on portal may not be the part of Act or vice versa. We all are struggling with. As a taxpayer, I'm under obligation to see my portal daily basis. What about tax officer? Why he will not see? When state has passed the order, again you are passing the order. Central is passing the order. Why there should not be judicial discipline? I'm only raising these concerns. This is for the nation. This is not blaming to anyone. We all are trying and we all are contributing for the nation growth and development. If at all we want GST to be simple, as stated by Honorable Prime Minister, good and simple tax. But nevertheless, what are the following guidelines need to be issued? After commencement of an inquiry or investigation by one authority, after commencement, another inquiry or investigation on same subject matter is initiated by different authority, then what are the guidelines need to be followed? So we want, if state has started on same subject matter, central should not start, or vice versa. But what are the guidelines? Listen, read the important conclusion part. Where a summon or so-called notice is issued by either the central or state to an SSE, SSE in the first instance obliged to comply by appearing. So even though it is being issued, you need to go and appear, furnish the requisite response as the case may be. We say so because mere issuance of summons does not enable either issuing authority or the recipient to ascertain that proceedings have been initiated. So meaning thereby at same point of time you are under investigation by central. If you are getting summon from state, you should first go and appear and submit your details and document. This is what being stated. B, where SSC becomes aware that matter being inquired into, investigated, is already subject of an inquiry or investigation by another authority. When being SSC, you come to know, SSC shall forthwith inform in writing authority that has initiated the subsequent inquiry or investigation. Upon receipt of such intimation from the SSC, respective tax authorities shall communicate with each other to verify the veracity of SSC's claim. We say so as this course of action would obviate needless duplication of proceedings and ensure optimal utilization of department's time, effort, and resources. Why only department? Even for the taxpayer. Bearing in mind that action initiated by one authority inures to benefit of all. So at least it looks like to me good. If center has initiated and I find the same subject matter when state is initiating, I must intimate the state authority so that at least I'm being relieved, but appear and submit the details and intimate. If the claim of taxable person regarding overlap of inquiries is found untenable, so when there is no overlap of inquiries, no proceedings, summon means no proceeding. Summon does not mean proceedings. Summon means only inquiries. Found untenable, investigation of two authorities pertaining to different subject matter, an intimation to this effect along with the region and specification of the distinct subject matter shall immediately be conveyed in writing to the taxable person. So on your writing to the authority, if tax authority come to know, no, it's a different subject matter, then they will also write back to you that we are doing inquiry on different subject matter. I hope it is being implemented in later and spread, so that at least we can see some ease of business for which we all are talking about. Taxing authority are well within their right to conduct an inquiry or investigation until it is ascertained that both authorities are examining the identical liability to be discharged. Same contravention alleged or the issuance of so-called notice. Any so-called notice issued in respect of liability already covered by existing so-called notice shall be quashed. Good one. However, if central and state, as the case may be, find that matter being inquired into, investigated by it, is already subject of inquiry or investigation by another authority, both authorities shall decide inter se which of them shall continue with the inquiry or investigation if they are finding same. In such a scenario, the other authority shall duly forward all material and information relating to its inquiry or investigation into the matter to the authority designated to carry the inquiry or investigation to its legal conclusion. We say so because taxable person, except being afforded the statutory protection from duplication of proceedings, otherwise has no locus to claim which authority should proceed with the inquiry or investigation in a particular matter. This is a very interesting one. On same subject matter, two authority, then one authority must forward and hand over the proceedings to the one authority, center or state. They may decide between themselves. And that one authority will take it to the legal conclusion and culmination of so-called notice. It should not end up a case that both are trying and beating the drum. It is good one. Because when Honorable Supreme Court saying that the protection under Section 6(2)(b) is only by issuance of so-called notice, then taxpayer must be given some relief when we look at summon proceedings initiated by two different authority. But only thing which I have seen in practical ground level reality, that even within central, sometime anti-evasion jurisdiction officer versus DGGI, and they are continuing with their summon proceedings. Within center, I'm talking. Here they are saying center and state. I'm keeping my finger crossed. I'm only looking for each of business. Let it be decided in the letter and spirit. However, where authorities are unable to reach a decision as which of them shall continue with the inquiry or investigation, then in such circumstances, when they are not in a position to decide, authority that first initiated the inquiry or investigation shall be empowered, word use shall be empowered, to carry it to its logical conclusion as per the circular. And the court in such case would be competent to pass an order. So in such cases, when both the authority is not deciding and both the authorities continuing with their summon proceedings, then in that case, he can go to the writ court under Article 226 and plead. And as per this Honorable Supreme Court judgment, they are saying that the authority who has initiated the summon proceedings, he will take it to the culmination. That is what it is being decided. If it is found that authority are not complying with these aforementioned guidelines, see, if authority, GST authority is not complying with these aforementioned guidelines, it shall be open to the taxable person to file a writ petition before the concerned High Court, jurisdictional High Court, under Article 226 to the Constitution of India. At the same time, taxable persons shall ensure complete cooperation with the authorities. It is incumbent upon them to appear in response to a summon and or reply to a notice. Before parting this matter, we deem it appropriate to make certain suggestion concerning the common IT infrastructure, IT, GST and portal shared by center and state. It is imperative that department act in harmony and maintain heightened vigilance with respect to intelligence inputs received by them, so as to give full effect to the legislative intent underlying the GST regime. Such coordination would also serve to mitigate the unnecessarily hardship caused to the taxpayer by overlapping proceedings and lack of interdepartmental communication. DGGI may consider adopting necessary measures to develop a robust mechanism for a seamless data and intelligence sharing between center and state, including provision for real-time visibility to both authorities of any action taken pursuant to an intelligence input, thereby advancing objective of harmony and cooperative federalism. Accordingly, present SLP is disposed of in the above terms. Pending application, if any, shall also stand disposed of. So this SLP, which was filed by petitioner against Delhi High Court judgment, and judgment was that High Court can't interfere with the proceedings, I will not say proceedings now, with the inquiry initiated by way of issuance of summon. So any inquiry which is for investigation and search, it's different it is not called proceedings when we look at section 6 subsection 2 clause B. Lot many factors we have discussed in this judgment which is being decided, and the crux of this Honorable Supreme Court judgment is very interesting and important. Let's see. But for a taxpayer, takeaway would be summon when issued by the department is different. It is only inquiry, which is different from the proceedings as referred under section 6(2)(b, which can happen only by issuance of so-called notice and adjudication, assessment thereof, either under section 73, 74, 76. So that is what the distinction. And secondly, the guidelines which is being provided on same subject matter, if someone is being issued, how the department would be interacting and how they can hand over the proceedings to other department. And wherever they are having difference of opinion, it must be initiated, it must be decided by the authority who has initiated the proceedings. So look forward that this all guidelines and provision as stated in the Supreme Court would be implemented. And of course, keeping in mind ease of business. And indeed, I'm of the opinion, honest taxpayer must be rewarded. Department is empowered to take enforcement action, intelligence-based, and they must take the action against those who are evading the taxes. But that kind of fire and burn should not be moved to the compliant and honest taxpayer. Some balancing act need to be done. We have to provide ease of business and real meaning of good and simple tax, as stated none other than by Honorable Prime Minister Sri Narendra Modi ji. With this, I'm summing up today's webinar. Hope you must have been benefited with a lot of digest which we have discussed at length. If any query in your mind, you can write back in a comment box. We will definitely reply you back. The judgment which I have shown during my discussion will be given in the description box, which you can download and read, where I've highlighted, colored, at least to that extent you can read for your immediate digest.